How about that po? Can you see the presentation this time? You said, ano yung hapon?
TV na
How about
may.
this one?
Dili pa ay.
Kita na.
Filter ito po.
Okay, so two is assigned with
Ikaw una
jurisdiction
na.
maps.
Ikaw una. Tulba ako ano.
It's not moving. I don't know what's happening. Should be able. Okay. Um, my part will revolve around reinstatement, back wages, damages and attorney's fees, separation pay, financial assistance, indemnity, and liability for um, corporate officials. As an introduction, when you say jurisdiction, it is the legal authority of a party to hear, try, and decide cases involving labor disputes, workers' rights, and employer-employee relations under labor code. When you say remedies, these refer to reliefs or benefits available to employees or employees when a right has been violated or a labor dispute has been resolved. Jurisdiction labor cases, there is the labor arbiters under the NLRC or the National Labor Relations Commission. It covers labor disputes, non-claims, and unfair labor practices. Also, the Golden Rule Directive, which covers small money claims not exceeding 5,000 cases, is under Article 129, and the NLRC itself, appeal jurisdiction over labor arbiters' decisions. This is under Article 224 of the Labor Code. My slide is not moving. I'm gonna change my I think I have a hard time with my signal with
We can have a restroom break for 5 minutes.
Thank you. So I can
Next time, just use the PowerPoint or save it as a PowerPoint presentation, not as a Canva file.
apologize for that.
Make sure that your names are in full name, the proper name that is recorded in your attendance. I cannot check your attendance if it's just your first name or a general name. Who is user? We cannot put a grade for you if you don't change your name. User.
I think it's needed. I'm sorry, I'm not quite familiar with this application yet. Can you hear me, dear?
Yes, yes, noted. Thank you. let's start. Please guide us.
Alright, going back, I will focus on reinstatement, wages, damages and authorities fee, separation pay, financial assistance, indemnity, and liability of corporate officers. Labor arbiter, jurisdiction of the labor arbiter is distinguished from the regional director, requirements to perfect appeal to labor, national labor relations, are also part of non-profit. Okay, I already presented this earlier, so I will just proceed. And so as well, the labor arbiters cover discrimination disputes, money claims, and unfair labor practices. As per the regional director, they cover small money claims not exceeding 5,000 under and for the NLS itself, for appellate jurisdiction over labor arbiter decisions under Article 224. So what is reinstatement? Reinstatement is defined as the restoration of legally dismissed employee to follow position. There are two types of reinstatement. That's actual reinstatement or payroll reinstatement. The basis of this is under Article 224 and 227 of the Labor Code. So there's a notable case here that starts reinstatement. That is the case of Humano versus NLRC, which are numbers 147 to 82. Okay. Actual reinstatement is placing the employee back in his or former job or an equivalent position. When we say payroll reinstatement, the employer pays the employee's wages while the labor dispute is pending. Reinstatement is determined by the nature of the dispute. Labor arbiter has jurisdiction, the NLRC, yes, it has also jurisdiction on reinstatement, voluntary arbitrators and court of appeals, and the Supreme Court as well. Back wages refer to the monetary compensation awarded to an employee to a legally dismissed employee. This amount represents the wages that the employee would have earned had they not been unjustly terminated from the time of dismissal until actual reinstatement or finality of the decision of illegal dismissal. More to back wages, the right to back wages is rooted in Article 2 and 4 of the Labor Code, which guarantees the security of tenure to employees. The provision explicitly states that an unjustly dismissed employee is entitled to reinstatement without loss of seniority rights and other privileges, as well as payment of full back wages. Moving forward, jurisdiction over back wages, the jurisdiction over cases involving back wages lies primarily with the National Labor Relations Commission and its labor arbiters. The NLRC has exclusive jurisdiction over claims for illegal dismissal and monetary awards, including back wages. Illegal dismissal cases, claims for back wages typically arise in the context of illegal dismissal cases filed before the labor arbiter. Labor arbiters are actually empowered to adjudicate cases involving reinstatement and monetary claims in excess of 5,000 pesos, basing on back wages, separation pay, and other labor standards violations. Remedies related to back wages. Number one is reinstatement. This is primary remedy for illegal dismissal. It is ordered without loss of seniority rights alongside full back wages. Now, if reinstatement is not viable due to strained relations or other factors, then separation pay may be awarded in lieu of reinstatement. Another is separation pay in lieu of reinstatement. When reinstatement is no longer feasible, back wages are awarded alongside separation pay. This is calculated based on the employee's length of service. Another is moral and exemplary damages. In cases where bad faith or employee may recover attorney's fees equivalent to 10% of the monetary award if back wages and other benefits are obtained through litigation. Okay, so here's a notable case here, St. Martin Funeral Home versus MLRC, which are number 3886. This case reinforced that back wages must be completed without deductions for employees. And another one is the Agapon versus MLRC. It clarified the entitlement to nominal damages alongside back wages for dismissal with proceeding benefits. Damages not only fees, moral and civil damages of dismissal attended by bad faith or malice. Attorney's fees may be awarded as a form of relief if an employee was compelled to litigate to recover wages, and that is enshrined in Article 111 rather of Labor Code, as well as under Civil Code is in 2229 to 2230. So there's also a notable case, the PLDE, or the Philippine Long Distance Telephone Company, that's PLDT versus the NLRC. It established that an employee dismissed for serious misconduct as an act of accepting bribes for phone installations is not entitled to separation pay. So let's talk about separation pay. Separation pay is granted in lieu of reinstatement when reinstatement is non-physical. The amount is generally computed based on the employee's length of service and latest pay rate. So here's a notable case here, Golden Ace Builders versus Talde, which was decided in May 5, 2010, was about a carpenter was illegally dismissed in 1999. Courts ruled for reinstatement, but strained relations led to separation pay. Back wages and adjusted separation pay were awarded, totaling 608,564.69 The key issue was whether an employee initially seeking reinstatement is entitled to separation pay when strained relations make reinstatement impractical. The court affirmed the employee's right to separation pay under these circumstances. Moreover, the Supreme Court's decision reinforces the principle that illegally dismissed employees are entitled to just compensation and that employers must provide a safe and productive work environment. The key issue was whether an employee initially seeking reinstatement is entitled to separation pay when strained relations make reinstatement impractical. Okay, the court affirmed the employee's right to separation pay under these circumstances. Moving forward with the financial assistance. Financial assistance under Article 3, Section 3 of the Philippine Constitution is granted as a social justice measure even if dismissal is valid. It is actually discretionary and not a matter of right. It is with a equivalent approach of labor law to balance interests of employers and employees. Of course, we have to look into the interests of the employers as well on top of the employees' interests. Moving forward is the case here between Toyota Motor Philippines Corporation Workers Association versus the NLRC, which we are number 15786, which was decided in 2007. The Supreme Court held that financial assistance cannot be granted to employees validly dismissed for just causes under Article 3 and 7 of the Labor Code. Financial assistance is inconsistent with the principle that no benefit goes to an employee guilty of serious misconduct. Indemnity. This is monetary award granted to an aggrieved employee as compensation for damages caused by an employer's violation of labor laws, employment contracts, or collective bargaining agreements. This CBA has been mentioned earlier in the jurisdiction over indemnity claims. There is labor arbiters under the NLRC, the NLRC itself, voluntary arbitrators, and the labor courts. Moving forward is a case between Japa Food Processing versus Outlook, a case decided in 2005. It recognized separation pay in lieu of reinstatement as indemnity for strained employer-employee relations. And here we go, the liability of corporate officers. The general rule is the corporation is not liable. The corporation is the one liable, not the officers. But there's an exception. Officers liable if they acted in bad faith. So a notable case, AC Ransom versus NLRC. Okay. Now let's go to the labor arbiter jurisdiction of appeals with reference to RA 8042 or the Migrant Workers and Overseas Filipinos Act of 1995. Now, I don't want to delve into the details of this because this was actually discussed in previous school. Labor arbiters plus quasi-judicial officers empowered to decide on labor cases. So these are the individuals who have more empowered to decide on labor cases. Exclusive and original jurisdiction over certain disputes. Appeals governed by the 2011 NLRC rules of procedure. Then here we go, the labor arbiters. Who are these? Under Article 222 of the Labor Code, these are members of the Philippine Bar, must have been engaged in the practice of law in the Philippines for at least 10 years, and with at least five years experience or exposure in the field of labor management relations. The labor arbiters shall have original and exclusive jurisdiction to hear and decide within 30 calendar days after the submission of the case by the parties for decision without extension. The following cases are within the jurisdiction of the labor arbiters. All workers, whether agricultural or non-agricultural. First one is unfair labor practices, discrimination disputes. Number 3, cases that workers may file involving wages, rates of pay, hours of work, and other terms and conditions of employment. Number 4, claims for actual, moral, exemplary, and other forms of damages arising from employer-employee relations. Number 5, cases arising from violation of Article 264 of this code, including questions involving the legality of strikes and lockouts. And moving forward with number 6, all other claims arising from employer-employee relations, including those of persons in domestic or household service involving an amount exceeding 5,000 pesos, regardless of whether accompanied with paid or reinstatement. Now, the jurisdiction of the regional director under Article 129 of the Labor Code, the recovery of wages, simple money claims not exceeding 5,000 pesos per employee, and other monetary claims from this is within the jurisdiction of the regional director. Okay, now let's have a distinguishing difference between the jurisdiction of the labor arbiter and the regional director. For the labor arbiter, termination disputes, unfair labor practices, money claims exceeding 5,000 pesos on OFW basis. On the other hand, with the regional director, small claims not exceeding 5,000 pesos and compliance orders as well. RA 8042 and OFW jurisdiction, OFWs with money claims can file before the labor arbiter. Decisions, final and executory after 10 days. OFWs are entitled to full reimbursement of placement fees and the post-mentioned na. And that's the landmark case of the Serrano versus Maritime Services. So I won't be delving that anymore. Appeal to the NLRC, labor arbiter decisions appealable to the NLRC. Appeal for
Nanate.
to continue the grounds for appeal. Serious errors in the factual findings that would be errors that would result in a grave injustice if not corrected. Number 2, decisions rendered without jurisdiction, labor arbiter exceeded or acted without authority. Number 3 is abuse of discretion, decisions issued in violation of due process. And number 4, fraud reclusion, decisions obtained through deceit or connivance. That would be all for my part. Now I'm giving the floor to Miss Reggie. Miss Reggie, take it away.
Thank you, ma'am. Good evening, everyone. Just wanted to check if you see my presentation. Hello.
Yes, Miss Reggie, you can see it.
Thank you. Good evening, Dean. Good evening, everyone. My name is Regina Manuel, one of the reporters from 2 under jurisdiction and remedies. So the National Labor Relations Commission um, is a quasi-judicial body in the Philippines tasked with resolving labor and employment disputes. So it operates under the Department of Labor and Employment, or DOLE, but maintains independence in its adjudicative functions. So basically, the NLRC derives its authority from the Labor Code of the Philippines, other known as Presidential Decree number 442 and related jurisprudence.
Bye.
So for the jurisdiction, first, to promulgate rules and regulations governing the hearing and disposition of cases. So basically, the NLRC, under this jurisdiction, NLRC has um, under how hearings are conducted, this is one of the jurisdiction that the National Labor Relations Commission and how cases are decided like the disposition. So basically, the NLRC sets the procedural rules that ensure consistency, fairness, and efficiency in how labor cases are handled and enforced. The second jurisdiction to formulate policies affecting the administration and operations. So the NLRC has the authority to create and adopt policies that guide how the commission is managed and run on a day-to-day basis. So these policies are not about deciding labor cases, but about ensuring the smooth functioning, efficiency, and organization of the NLRC itself. So the NLRC um, within this jurisdiction sets the internal rules and policies on how the commission should be managed, organized, and operated. The third jurisdiction to allow cases within the jurisdiction of any division to be heard and decided by another division. So the NLRC has the power to reassign cases from one division of the commission to another division. So, but if it's but if this is case to case basis. So if circumstances require, for example, heavy caseload, conflict of interest, or need for faster resolution. So basically, the NLRC can order that a case pending in one division can be transferred to and decided by another division. So this is to ensure the fairness and proper administration of justice. The fourth one of under jurisdiction is to recommend the appointment of labor arbiters. So the NLRC, the National Labor Relations
Where is
Commission.
the representation?
Sorry, Dean. But it indicate that. So how about this? Wait, make sure.
Yes.
you.
Yes.
Thank you, Dean. Let's continue. So for the fourth jurisdiction, the NLRC or the National Labor Relations Commission um, can recommend an appointment of labor arbiters to the President of the Philippines who makes the actual appointment. By recommending candidates, the NLRC ensures that only those who are qualified, competent, and fit for the role are considered by the President. Exclusive affiliated jurisdiction. So under Article 224, as discussed by the first reporter, the NLRC has exclusive affiliate jurisdiction, meaning it is the only body authorized to hear cases or hear appeals from certain decisions. So overall cases decided by labor officers and other cases decided by non-regional directors under Article 129. So if it's exceeding 5,000, it would go to the labor arbiters. And of course, if it's below 5,000, it would be under the other regional directors under Article 129. So the NLRC um, is composed of 8 divisions. Each division is made up to 3 commissioners, 1 presiding commissioner, and 2 commissioners. So the functions of the divisions. So each division exercises quasi judicial power, meaning they hear and decide labor cases that are appealed from the decisions of labor arbiters. They act like panels that review and resolve disputes, and decisions of a divisions are made by a majority vote of its three members or 3 commissioners. So for the NLRC function, so when sitting in a compulsory arbitration certified to by the Secretary of Labor, the NLRC is tasked to implement the order of the Secretary as an administrative body, not as a judicial court. So meaning for this is that um, NLRC does not decide cases or interpret the law. Instead, it executes or enforces what the Dollar Secretary has already ordered. The second one, to formulate the terms and conditions of the CBA staying within the scope of the order. So NLRC can be directed to set or finalize the provisions of a collective bargaining agreement between the employer and employees, but it must follow the limits and guidelines given by the Dollar Secretary's order. So the third one, to act within the earliest time possible and with the end in view that its action would not only serve the interests of the parties alone, but would also have favorable implications to the community and to the economy as a whole. So these are the remedies under the NLRC. So for the reinstatement pending appeal, so if reinstatement is ordered, it must be enforced immediately, even during the appeal process. So under remedies after the NLRC decision, as the reporter and the first reporter discussed, so parties may file a Rule 65 petition within 60 days from the NLRC's final decision, alleging grave abuse of discretion. And for the final decision, NLRC decisions become final and executory 10 calendar days after receipts of the decision if no appeal or motion is filed.
That's
So,
the way.
so these are the sample cases under the NLRC, like the GR number 164573. Alright, for the Court of Appeals, so as defined, the Court of Appeals plays an important role in social legislation in the Philippines as well as in labor cases. And the Court of Appeals review in labor cases is limited to determining whether there is grave abuse of discretion. Second, substantial evidence. The third one is due process compliance. The Court of Appeals must evaluate whether the labor arbiter or the NURC according for this procedural due process. And the, of course, practical implications under employers, employees, and practitioners. So the employers should ensure procedural compliance during NLRC proceedings to avoid certiorari challenges. And under employees should exhaust administrative remedies to preserve their right to seek redress in the CA. So practitioners must carefully frame certiorari petitions, focusing on jurisdictional issues and procedural flaws rather than re-arguing factual findings. So sample cases under Court of Appeals. Under Supreme Court, and yes, Supreme Court of the Philippines also play an important role in labor law and social legislation. They are particularly in exercising public jurisdiction as well as the rulings on legal disputes involving labor standards and relations. So the jurisdiction of Supreme Court reviews decisions, resolutions, or orders of the Court of Appeals and the National Labor Relations on labor disputes that involve questions of law. This involve only other questions of law. So under Rule 45, the Rules of Court, appeals to the Supreme Court are limited to pure questions of law only. As you
So, next report.
For Miss Berigi, I'll be the one who present her topic.
She's not here, Miss Villegas.
Good evening, everyone. I'll be speaking about I'll only cover the key points and highlights the important points and findings. So, for our first part, for police power, so what is the relation of labor law as part of the police power of the state? So, labor law is part of the police power because labor relations have become public interest, creating an inherent inequality between employer and employees that the state must address to ensure the general welfare of the society. So, in other words, labor contracts are non-ordinary contracts. Rather, these are indeed in public interest and a profit, and thus, proper subject to police power measures of the state. In the case of San Fernando Coca-Cola versus Coca-Cola Bottles Philippines, wherein the court held that the powers given to the police secretary under Article 263, paragraph G, is an exercise of police power with the aim of promoting public good. So in fact, the scope of power is basically limited to an industry indispensable to the national interest as governed by Article 265. Next slide, please. So what's the jurisdiction for the body secretary? So we have the regional jurisdiction. So in the case of Bago Pagkakasala ng Batawa versus Secretary of the Department of Labor, the court held that the body secretary's power to assume jurisdiction is a full authority to resolve all matters within the dispute that gave rise for those to or arouse of strike or lockout. So it includes and extends to all questions and controversies arising from or related to the dispute, including cases over which the labor arbiter has exclusive jurisdiction. So there are other powers of the legal secretary. We have the quasi-judicial authority, which the body secretary is applying jurisdiction of cases decided by the regional directors. We have administrative powers. So the body secretary has administrative power supervision and control over the agency's personnel and programs. So we have policy-making functions, which the secretary sets the direction for labor and government policies. Next slide, please. So, what is the doctrine of great threat of discretion? So, the doctrine, in the case of the powers of the Secretary in National Affairs, this is not by limits and bounds. Rather, the Secretary is given wide latitude to appropriate means to resolve the final resolve the labor dispute. So, the great threat of between as in the case of University of the United Constitution versus the Secretary of the Government, wherein the court held that the great threat of discretion possessed by the Secretary dates back to earlier rulings which recognized that the broad powers of the foreign court of industrial relations, which the CIR, which had jurisdiction of the national president, prior to the enactment of the labor code. So, in the Secretary's exercise of such broad discretions, the prevailing rule is that the court will not interfere or substitute the Secretary's judgment with their own unless the grade of this is shown and determine whether the acts of the Secretary constitute the grade of use of discretion, the standard of reasonableness must be applied. So, so the abuse of discretion must be so patent and gross as to amount to a violation of the positive or to willful refusal to perform a duty given by law. So that would only be the case wherein the court would interfere with the secretary of, of the bodies, decisions and discretion. So next slide. Okay. So the plenary and discretionary power of the secretary of body. So in the case of so can you speak more about the next part? So we have the physical powers and the working powers. This, so I will first explain between the physical powers. So the physical powers is a classification. One side is moral, second is the administrative power of the secretary of government because even without the need of um, the the knowledge secretary mandate an order or may mandate an order or issue based on the report of the inspectors. So we have the previous final hours of the secretary of police. And first we have Article 37. So Article 37 of the Labor Code pertains to recruit duties. So the Secretary of Labor or these duly authorized representatives upon their own initiative, without the need for any complaint or yeah, for any complaint, they can go to any agency, um, examines or determines or introduce the employees of that agency and other artifacts of the business that can serve as basis coming from the regional director or any recruitment agency. And to determine whether or not there are serious violations within that agency, like illegal recruitment or violate or commissions of any prohibited acts. So that would be under Article 15, and Article 34 and 38 of the Labor Code. So we have the second power of the Secretary of Labor, which is Article 120. So this is much more broader and encompasses the biggest power of the labor secretary. So because it covers all kinds of establishment. So an establishment refers to any commercial, agricultural, or industrial unit, whether they are large scale or small unit or small company. As long as there is one employee, the secretary or his duly authorized representatives may pay visit to the they can be visited by the regional directors or the inspectors for any authorized, as they are authorized by law to examine payroll, the working conditions of the employees, and to determine whether or not there are like violations or there is compliance with the labor standards and occupational safety and conditions
Yes.
within the labor code. So we have last we have the last hours, which is Article 289, and which is 289 pertains to labor unions, and the only time to see is um, and only time the labor arbiter, I mean the secretary of DOLE can inspect is that when there is a petition coming from the members of the unions to audit the books or the accounts of the labor officials or if there are violations with in accordance with the constitutions and bylaws with or whether or not there is a malversation of funds. Next slide, please. Okay, so we have the enforcement power. So according to Article 128, Paragraph A, the call to ensure compliance. So the secretary shall have access to employees' records and premises at any time of the day or night, whenever work is being undertaken. So we have 128. The execution of judgment. The secretary shall issue writs of executions kapag hindi na-comply yung employer sa employer decision ng Secretary of Law. So the execution would then be issued by the Secretary. So we have 128, which is the suspension of work. So the Secretary of Labor will likewise order stoppage of work or suspension of operation of any unit or department in an establishment. So we have the imposition of penalties. So Article 128, Paragraph A, the amended reference, it should be unlawful. And the amendment shall be unlawful for any purpose or to obstruct, impede, delay, or otherwise render ineffective the orders of the Secretary. Like no imperial court or entity should issue temporary or permanent judgment. So the courts will not be it is not within the discretion of the court to interfere with the decision of the Dalit. So we have lastly the imposition of penalties and government found guilty of violations or abuse of authority under this article be appropriate for administrative investigation or dismissal from the service. So we have next slide, please.
Okay, thank you, Ms. Balichi. So, reporters, I will read two questions or six questions, by the way. Six. Those that are directly related to your reports, some may be answered by the next reporters, the next groups. Why is legal dismissal always with the labor arbiter's jurisdiction and not the DOLE's? Why do you think is illegal dismissal always within the LA or labor arbiter's jurisdiction and not the DOLE?
To answer that question, Dean, it's always the labor arbiter who has the jurisdiction over illegal dismissal cases because it's the labor arbiters who can give viable judgments on whether the case really is an illegal dismissal or not.
And how does jurisdiction affect the enforceability of reinstatement, back wages, or other monetary claims in labor disputes? How does jurisdiction affect the enforceability of reinstatement, back wages, and other monetary claims in labor disputes?
If I may heard it right, how his jurisdiction affects the enforceability of back wages, the separation, and just
Reinstatement, wages
And
and other monetary claims.
it's the NLRC and the labor arbiters who have exclusive jurisdiction over this matters. They have the provisions over these cases.
So if it's not filed with the LA, what would happen with the proper jurisdiction? What would happen?
If it's not filed within the proper jurisdiction, the case shall be dismissed since jurisdiction is always prerequisite to proper filing.
Fourth question, what is the primary role of the NLRC in the Philippine labor justice system? What is the primary role of the NLRC in the Philippine labor justice system?
The NLRC has the NLRC's primary role then is pertains to labor relations, the employer-employee relations, and the benefits and the interest of the two.
Fifth, second to the last question, what is the visitorial and enforcement power of the Dole Secretary or SOLE? When we go to review, Secretary of Labor and Employment is SOLE, and his duly authorized representative under Article 128. What is the visitorial and enforcement power?
So the power of this the power of this power of the legal secretary is to inspect or examine the working conditions or determines whether or not there are serious violations with the conditions or there is a compliance with um, the labor standards as provided by the labor code. Whereas the enforcement powers of the legal secretary is to ensure that whatever violations that has like manifested in they will be given appropriate measures and appropriate measures for that.
And last question, how should cases falling under the jurisdiction of the voluntary arbitrator but erroneously filed with the labor arbiters or DOL regional offices be processed? How should cases falling under the jurisdiction of the VA or the voluntary arbitrator but erroneously filed with the labor arbiters or DOLE regional offices be processed? So for the next groups, just an observation. When I'm giving you an opportunity to research ahead, because I asked your classmates to post their questions in advance. So the reporters who are done first has the responsibility to at least prepare a basic answer based on your chat or comment section. So if you're not able to answer, it will be a deduction on your recitation or in your presentation made for your reporting. And then there is no coherence or uniformity in your presentation. Some has different slides or different approach on the reporting. So I don't think there is a teamwork in your group. I'm checking how you collaborated with your classmates or your team. So that's part of your grade. That's part of your presentation. And then most of you again read on your presentation. So there is no interaction or creative um, or fun activity so that your classmates will be learning more as you present, as you conduct your activity. So that's one. I hope all of the rest of the groups will be able to improve your presentation. The next group for next week will be group 3 and 4, right? September 8th. So on Saturday, we'll have a quiz based on the reporting tonight. And then we'll have also later after the midterms, I'll be asking you to make an infographics on the remedies, how the unfair labor practice or the illegal dismissal will be filed. So the step-by-step process of those common cases and related. So just research in advance, and this is information overload for those who are not familiar with labor laws. We'll stop here, we'll end here so that you'll be able to prepare for Saturday's quiz. And then I hope the next presentations will be better. I'll give siguro additional points for group 1 and 2, but I'm not very satisfied. So I'm looking for something new. I'm looking for something different in your presentation. I hope the rest of the groups will improve. So thank you for tonight and see you next Monday. The quiz for Saturday will be online through the Google Forms.
Din, good evening,
Yes.
Yan, dito si DYM din if kanang sa tuwa daw Saturday classes kay mga klase ba daw ta always kay o daw yung basis kung may online niya ang insurance or EF to F kay sunod jud kayo yung klase mo gutin 1 to 2 yung mga tas kay din usually supposed di online to sa schedule kung galit lang siya ka F to F dayon hindi namin nga online ang mo ang 1 to 2 tas ana siya nga magkuan sa daw iasa daw ka F kanang always ba daw ta kanang mag-class if Saturday kaya daw ma-online ko niya yung insurance
Online sa insurance.
yes din kay lisod ko kayo if mo to pag school malate me niya sayo kay na si din wala pa yung alas 2 na nasa dito
So I'll tell her that we'll be conducting activities, quizzes, group activities during 1 to 2 through online. So there will be a breakout group. Pero wala niya akong hangyo sa inyo. Ayoko ninyo ilaglag. So, kung na may traitor, suntiin na lang ko kay para hindi na padayon mo. So, I'm helping you in my own way. Pero kung hindi mo ganahan, pagpili na lang ko. No? I think na hindi nyo itaasa. Kanang, as much as possible, I'm helping you. Pero ayaw sa ko ninyo ilaglag or ipahamak. So, I hope that this is an agreement. I'm holding on to your word na diligid ko ninyo pahamak kay din. So, you tell her that we'll be having online quizzes and online activities through Zoom. So, there will be group activities for you. And, so, although naman yun, sometimes, especially ani lang ha, be prepared if there are series of cancellations, di ba? Usahay, sunod-sunod na ang mga walay classes. So, I'll be getting the Saturdays from you for our class. So, be prepared, Ana. So, dili gyud siya meaning na wala tayo class, nagyapon tayo class. Pero I hope na when I give you time for preparation sa inyong Monday na work, ay pwede niyo ipakita sa inyong din relax remote. So, please avoid that. Kanang ipakuan po sa iya you're still preparing, you're still doing your assignments and other requirements. So, other questions?
we just have a concern for the group 10. One of our member is not it's not responsive with our group chat, as well as we try to mention him on the general group chat for labor. And we just have a concern regarding his part. Kay, but if dili siya magpanghabang, naiputol report. Si Mr. Si Mr. Sura Suraninog din.
Is he here? I think he's here.
Dear body. But I am in
Mr.
affiliate.
Mr. Suraino, are you responding to
Adin, I just have to clarify, I belong to group 11 of, initially, it was listed on group 10 also din, so kasi it wasn't a group 11, not everything, so sa 11 kaya.
11 siya? Okay, siya. Group 11. Group 11.
Right, thank you.
Okay. Other concerns? Okay na? Okay, so any questions you ask Ms. Picato to message me. So thank you everyone. Thank you for tonight's discussion. I'll see you next Monday. And good luck on your case on Saturday.
Thank you, Dean.
Thank you.
Kayo pagka-print.